Welcome to This Week in Education Law, where I share up to date court decisions from the perspective of educational administrators and policymakers. This is episode 42. In this episode, I'll introduce a recent case about a former public school principal who alleged retaliation by the New York City Department of Education after she complained about racially segregated sports teams at her school. This case addresses important questions about the scope of Title VI protections against discrimination in federally funded programs and activities. Here is the background of the case. Joe Bloomberg was a former principal of Park Slope Collegiate, one of the four public schools housed at the John Jay campus in Park Slope, Brooklyn. As of 2014, Park Slope Collegiate's student body was 85% Black and Latino. In 2010, the New York City Department of Education announced that Millennium Brooklyn, an affiliate of the predominantly white Millennium High School in Manhattan, would join the John Jay campus, fearing that Millennium Brooklyn would become a white enclave within the campus. The school principal publicly opposed the move and advocated against discrimination and segregation at the Park Slope Collegiate. The principal's statements drew several informal reprimands from the DOE. Ultimately, the principal's opposition failed and Millennium Brooklyn joined the John Jay campus. 7 years later, on January 10, 2017, the principal emailed the CEO of the DOE's sports team and the superintendent of her school district regarding the allocation of sports team at John Jay. She noted that Millennium Brooklyn, which shared its athletic program with its Manhattan sister school, had a separate sports team from and almost twice as many as the other John Jay schools. This separation sports programs, she wrote, offer vastly unequal opportunities to students. The principal included a chart showing a number of sports teams for Millennium Brooklyn versus the rest of John Jay, the total enrollment at each school, and the percentage of Black and Hispanic students at each school. She then described the sports program as separate and unequal. The principal claims to have never received a meaningful response from her email. 2 months after sending this email, the principal was informed she was under investigation by the Department of Education's Office of Special Investigations. The investigation was based on an anonymous allegation from May 2016 that Bloomberg had tried to recruit students to a communist organization. Though this investigation had initially been closed due to lack of information, it was reopened in January 2017, shortly after the principal's complaint about the sports teams. The investigation ultimately did not result in disciplinary action beyond a written reprimand. The principal alleged it damaged her reputation. She subsequently filed a lawsuit against the DOE, claiming the investigation was retaliation for her complaint about racial discrimination in the athletic programs. This formed the basis of her Title VI retaliation claim that is at the center of this legal case. The United States Court of Appeals for the Second Circuit confirmed that individuals can sue under Title VI of the Civil Rights Act if they believe they will face racial discrimination in federally funded programs like public schools. Title VI prohibits a recipient of federal funds from retaliating against someone who complains about discriminatory conduct prohibited by the statute. In this case, the public school receives federal financial assistance under Title I of the Elementary and Secondary Education Act, which funds schools with a high percentage of low-income families. Title VI of the Civil Rights Act of 1964 specifically applies to any program or activity that receives federal financial assistance. It states, no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. In essence, any school, school district, or higher education institution that accepts federal money for any purpose must comply with Title VI non-discrimination requirements across all programs and activities. The court also noted that it is illegal for schools to retaliate against someone who reports discrimination. This means if you speak up about discrimination, you are protected from punishment for doing so. An important part of the court's decision in this case is about a section of Title VI called Section 604, which can be a little bit tricky to understand. Section 604 of Title VI states, "Nothing contained in this subchapter shall be construed to authorize action under this subchapter by any department or agency with respect to any employment practice of any employer, employment agency, or labor organization, except where a primary objective of the federal financial assistance is to provide employment." What does it mean? Section 604 says that Title VI generally cannot be used for complaints about employment practices. This is because there is another law, Title VII, that deals specifically with employment discrimination. But here is the key point. The court interpreted this to mean that Section 604 only blocks claims when the person is complaining about employment discrimination. In this Bloomberg's case, the school principal Bloomberg was not complaining about her own employment or anyone else's job. Instead, she was reporting what she saw as discrimination in student sports teams. This is about student opportunities, not employment practices. So, if a teacher complained that they were denied a promotion because of their race, that would be an employment issue and they could not use Title VI to sue. But if that same teacher complained about students of color being denied equal access to advanced classes, that's not an employment issue. It's about student treatment. So Title VI can apply. The court did not make a final ruling in favor of the principal on the merit of her case. However, the court decision was generally favorable to her position. The Court of Appeals vacated, essentially overturned, part of the district court's judgment that had dismissed the principal's Title VI claim. The court concluded that the principal's claim of retaliation for reporting non-employment-related discrimination could proceed under Title VI. The case was sent back to the lower court for further consideration. The district court will now need to examine the merits of the principal's claim, including whether her email constituted protected activity and whether there was a causal connection between her report and the alleged retaliation. What can educational administrators learn from this case? The key takeaway is this. If someone in your school or school district, whether a teacher, staff member, or principal, or district administrator, reports discrimination against students or sport teams, class assignments, or disciplinary practices, they are protected from retaliation under Title VI of the Civil Rights Act. If you make a retaliation claim, you have the burden of proof. This means it is your responsibility to provide evidence that supports your retaliation claim. You engaged in protected activity like reporting discrimination. Your employer knew about this activity. You suffered an adverse action, and there is a connection between your report and the adverse action. First, you engaged in protected activity. This could include reporting discrimination, participating in an investigation about discrimination, or opposing discriminatory practices. For example, if you complained to HR that students of a specific racial group were being unfairly excluded from advanced placement classes, that would be a protected activity. Second, your employer knew about this protected activity. There must be evidence that the relevant decision makers were aware of your protected activity. If you sent an email to the school board about unequal funding for girls' sports teams, you need to show that they received and read that email. How do you prove that? Any replies to your email, even if just acknowledging receipt, can serve as evidence that it was read. If the content of your email is referenced in subsequent meetings, memos, or other communications, this suggests the email was read. If colleagues or supervisors mention the content of your email in conversations, this suggests it was read or discussed. In some cases, it may be possible to obtain server logs that show when the email was accessed. During legal proceedings, decision makers could be asked under oath whether they read the email. If you receive any follow-up questions or request for clarification about your email, that indicates it was read. You don't always need to prove with absolute certainty that an email was read. Often you need to show that it's more likely than not that the decision makers were aware of your protected activity. This can sometimes be inferred from the circumstances, even without direct proof of the email being read. Third, you suffered an adverse employment action. This could be any negative employment actions, such as demotion, salary reduction, transfer to a less desirable position, or even termination. It could also include less obvious actions that would deter a reasonable person from making a complaint, such as increased scrutiny, poor performance reviews, or exclusion from important meetings. Fourth, there is a connection between your report and the adverse employment action. You need to show that the adverse action was because of your protected activity. This is often demonstrated through timing. The adverse action closely followed your protected activity or complaint, or through different treatment. Others who didn't complain were not subjected to similar actions. If you report discrimination on Monday and by Friday you were suddenly transferred to a less desirable position, the close timing could suggest a connection. If you were the only employee given an unsatisfactory rating shortly after reporting discrimination, while other employees with similar performance who did not report anything received satisfactory ratings, this could suggest a connection. Remember, you don't need to prove that discrimination definitely occurred in your initial report. This is a common misconception that often confuses people. The law does not require you to be 100% correct in your assessment of discrimination. What matters is that you had a reasonable belief that the discrimination was occurring when you made the report. Reasonable belief means that a reasonable person in your position with your knowledge and experience would have thought discrimination was happening. If you raise concerns about gender bias in hiring practices and were then excluded from important meetings, your retaliation claim could focus on that exclusion, not on proving definitely that the hiring practices were gender biased. The law protects people who speak up in good faith, even if they turn out to be mistaken. And this encourages people to report potential discrimination without the fear of retaliation if they can't ultimately prove it. If people had to be certain they could prove discrimination before reporting it, many legitimate concerns may go unreported.